Good afternoon, Hong Kong, and a very early good morning from London. I am Ellie Mulholland, the Director of the non-profit Commonwealth and Climate and Law Initiative, or CCLI. I'll be your host for today's webinar. We'll be discussing directors' responsibilities and climate change under Hong Kong law. And this event is jointly organised with the Asian Institute of International Financial Law at the University of Hong Kong, and we are very grateful for their support. There is overwhelming scientific consensus that human activities such as the burning of fossil fuels, land clearing and agriculture contribute significant volumes of greenhouse gases into the atmosphere. And this human-induced climate change is already having a profound effect across the world. But we have the roadmap for solutions. At last month's Glasgow's COP26 climate summit, the world's governments reaffirmed their shared commitments to the goals of the Paris Agreement to transition to net zero emissions and limit warming to well below 2 degrees and to strive for 1.5 to avoid the most catastrophic impacts of warming. This means we need to halve emissions in the next decade, which requires systems transitions across our economy. And with this scientific consensus on climate change and that global agreement to transition to net zero emissions, climate change has rapidly evolved from a singularly ethical or environmental issue. And it's now widely recognised that it presents risks and opportunities for business and investment by leading market stakeholders, including institutional investors globally, credit rating agencies, and financial regulators, including the FSC, the Hong Kong Markets Authority, and the Hong Kong Stock Exchange here. So what does this mean for company directors in Hong Kong and their duties to act in the best interests of the corporation and exercise due care, skill and diligence? Well, today our speakers are here to explore these issues, and we have two terrific resources that will help guide that discussion. A legal opinion by Mr. Alex Stock, Senior Counsel, and Ms. Jennifer Fan of Temple Chambers in Hong Kong regarding directors' duties and disclosure obligations in respect of climate change under Hong Kong law, as well as a white paper by Professor Ernest Lim, which builds on that legal opinion and explores some additional avenues there too. First, some housekeeping. Please submit any questions you would like our speakers to answer by the Q&A function in the bottom of your screen. And the first portion of the webinar with our speakers' presentations and remarks will be recorded. And now to introduce our speakers. They have generously volunteered their time to share their expertise and insights with you today on this important issue. We have Dr. Emily Lee, the Director of the Asian Institute of International Financial Law and Associate Professor at the Faculty of Law at the University of Hong Kong. We have Professor Ernest Lim from the Faculty of Law at the National University of Singapore. He's author of the white paper on directors' liability and climate risk under Hong Kong law that we are discussing today. And earlier this year, he authored the CCLI's white paper on Singapore and is a co-author of a legal opinion under Singapore law called the Chan Opinion. We have Ms. Christine Lau. She is the Assistant Vice President of the Listing Department at the Hong Kong Exchanges and Clearing Limited. And she works on Policy and Secretariat Services Unit of the Listing Division, bringing insights on the regulation of Hong Kong's capital markets on this issue. We have Ms. Alex Bidlake, corporate partner at Linklaters, with extensive experience advising corporates, financial sponsors and financial institutions on a range of public M&A transactions, private equity deals and issuances. She's a trusted advisor to Hong Kong corporates and directors. And Ms. Sarah Barker, partner and head of climate risk governance at law firm Minter Ellison, leading its international climate risk team. And she's the CCLI's Australian convener and recently co-authored our US paper on climate change and fiduciary duties that's been featured in Forbes, the Harvard Corporate Law School Forum and the D&O Diary. Now, in the interest of time, I won't read you their full biographies, but we'll pop a link in the chat if you'd like to refresh on their significant expertise. And without further ado, I would like to invite Dr. Emily Lee to provide some introductory remarks on behalf of our co-host, AIIFL.
Thank you, Ellie. Good afternoon. My name is Emily Lee. I'm the Director of the Asian Institute of International Financial Law, AIIFL, a research center housed at Faculty of Law of the University of Hong Kong. As a co-host of today's webinar on environmental, social, and governance, ESG, and directors' duties, I would like to extend our warmest welcome to our participants. I would also like to thank our counterpart, the Commonwealth's Climate and Law Initiative, CCLI, with their cooperation and coordination in organizing this joint center event. Despite company and financial laws being the focus areas of the AIIFL, ESG is relatively new and unfamiliar to us because the topic usually falls within the remit of environmental law. Unlike our sister institution, the University of Singapore, which has an environmental law center under the Faculty of Law, we do not have the equivalent in our faculty. However, ESG will be an incubated program for the AIIFL. The reason is at least twofold. First, ESG is an emerging area that is of strategic importance to Hong Kong. Second, the ESG issue is closely linked to the green bonds issued in the Greater Bay Area, GBA. The GBA is an integrated economic, business, innovation, and technology hub that aims to bring together the two special administrative regions of Hong Kong and Macau, with 9 cities in the Guangdong province in China, as shown on the slide. According to the Hong Kong Trade Development Council, the GBA has been a feature of a number of China's national strategies. Why is the ESG issue so important for Hong Kong? What is clear is that locally, both the government and financial regulators in Hong Kong have been proactive in promoting the strategic importance of ESG. Here are some examples. First, the Hong Kong Monetary Authority, HKMA, the de facto central bank and the banking regulator in Hong Kong, has assisted the government in issuing a total of US $3 billion in green bonds. Not only that, plans are being made to expand green bond issuance for retail investors and the Greater Bay Area. In 2019, the HKMA launched a 3-phased approach to promote green and sustainable banking. Phase 1 aims to develop a common framework to assess the greenness baseline of individual banks and to collaborate with international bodies to provide technical support to banks in complying with green principles. Phase 2 engages the industry and stakeholders in a consultation on the supervisory requirements on green and sustainable banking. Once ESG targets are clearly laid out, phase 3 of the approach entails the implementation, monitoring, and evaluation of banks' adherence to such green principles and requirements. The HKMA has strengthened its supervisory role in promoting a greener banking system in Hong Kong. The effect can be far-reaching for the industry in terms of compliance reporting and supervisory monitoring. Promotion of ESG also became evident when Hong Kong securities regulator, the Securities and Futures Commission, SFC, started referring to both ESG and GBA in its 2018 to 2019 annual report. Then in August 2021, the SFC concluded its consultation on management and disclosure of climate-related risks by fund managers by recommending the enhancement of 4 key elements: governance, investment management, risk management, and disclosure. Apparently, the ESG-focused regulatory reform is underpinned by the strategic framework for green finance, which was published by the SFC back in 2018, covering regulatory requirements on listed companies and asset management, supporting investor awareness of ESG-related investment products, and promoting Hong Kong as an international green finance hub. In 2020, the SFC and the HKMA co-chaired and initiated the statement of the Green and Sustainable Finance Cross-Agency Steering Group, which aims to coordinate and manage cross-industry ESG issues and the government's climate strategies. Other members of the steering group are the Environment Bureau, the Financial Services and the Treasury Bureau, the Hong Kong Exchanges and Clearing Limited, HKEX, the Insurance Authority, and the MPF Schemes Authority. As a market regulator, the HKEX first introduced its ESG reporting guide in 2013, and since then has continued to upgrade the disclosure obligations of listed issuers. Echoing the HKMA's three-phase approach, the HKEX has heightened reporting and ESG disclosure requirements for listed companies. Specifically, the HKEX has published an ESG reporting guide, which is embedded in Appendix 27 of the main board listing rules that details mandatory disclosure requirements and comply or explain provisions. To avoid greenwashing, paragraph 9 provides that the issuer may seek independent assurance to strengthen the credibility of the ESG information, which must be disclosed in their annual reports. Paragraph 10 further provides that the board has an overall responsibility for an issuer's ESG strategy and reporting. These reporting guidelines further supplement the HKE's existing Corporate Governance Code and Corporate Governance Report. Such ESG reporting requirements will most likely shape the way directors discharge their duties, since they are required to adhere to environmentally conscious regulations and proactively foster ESG initiatives in and outside of the company. On a global level, ESG is also being promoted by Hong Kong. As recent as November 2021, the HKMA issued a statement to support the Central Banks and Supervisors Network for Greening the Financial System, NGFS, Glasgow Declaration. The declaration aims to further contribute to global responses required by the Paris Agreement and, in the meantime, commit to expanding local green principles and methodology in undertaking reporting and disclosure requirements. Given that the HKMA is a member of the NGFS, this statement helps ensure that companies can better identify and manage risks with a more comprehensive due diligence process, which is integral to the development of ESG and overall corporate governance regarding ESG. In conclusion, ESG initiatives and working groups are becoming increasingly prevalent in Hong Kong. While these initiatives are so important, in order to maintain sustainable finance both regionally and globally, Hong Kong must be proactive. It must be forward-thinking. Given the importance of ESG and the GBA, we are keen to be a part of the discussion and will be hosting more events in the near future. Thank you.
Thank you so much, Dr. Lee. And now I will call on Professor Ernest Lim to summarize the findings of the legal opinion and the accompanying white paper that the links have been shared in the chat function. Over to you, Ernest. We've still got you on mute, Ernest.
Right. Thank you very much, Ellie. let me give you a roadmap of my short presentation. I'll first summarize the climate-related risks, and then I'll talk briefly about the financial and corporate measures taken by the Hong Kong regulators, and then I'll look at the key points in the legal opinion and the white paper. Climate change presents three major risks. They are physical, transition, and liability. Now, given that Hong Kong is an international financial center with extensive and sophisticated business operations related to asset management, insurance, as well as investment banking and brokerage, these sectors are vulnerable to the transition risk of climate change, and the insurance sector is particularly susceptible to both transition and physical risks. Physical risks, of course, include extreme weather conditions and other kinds of weather changes. Tropical cyclones have resulted in serious financial losses to Hong Kong. For example, the financial losses caused by the damage resulting from Typhoon Hato in 2017, such as flight cancellations, business closures, stock market suspension, amounted to Hong Kong $8 billion. In 2018, Typhoon Mangkok resulted in extensive flooding, causing damage to property. As a result, insurance claims of Hong Kong $3 billion were filed. Now, transition risks relate to the risks that companies will be subject to as a result of the actions that they have to undertake in order to make the transition to a net zero emissions economy. Under the 2016 Paris Agreement, the parties agreed to limit the increase in global warming to below 2 degrees Celsius and to take efforts to limit it to 1.5. As a result of the Paris Agreement, the Hong Kong government launched its Climate Action Plan 2050, which set forth various ambitious targets, such as to reduce carbon intensity by 40%, reduce carbon emissions by half, and to reach carbon neutrality by 2050. The document also set out various strategies in relation to decarbonization and renewable energy systems. An important output arising from COP26, the Glasgow Climate Pact, which essentially affirmed the Paris Agreement, and more than 100 countries, including China, agreed to stop and reverse forest loss. It is impossible to talk about transition risks without mentioning the G20 Financial Stability Board Task Force on Climate-Related Financial Disclosures, also known as the TCFD recommendations, which set out the disclosures regarding the impact of climate risks on business conditions. Many organizations in Hong Kong have signed up to the TCFD recommendations, such as the HKMA, SFC, and the Hong Kong Exchanges and Clearing Limited. Liability risks pertain to the potential legal claims or regulatory proceedings to which companies and their directors would be subject. Now, these claims can arise from breaches of different statutes and regulations and violations of the common law. According to one study, there have been more than 1,800 cases as of July this year, coming from more than 40 countries. There are two main types of cases against companies: corporate contribution to climate change and corporate failure to disclose climate risks. With regards to corporate contribution to climate change, NGOs have sued US companies based on a tortious course of action comprising negligence and nuisance, alleging that these companies have caused environmental degradation, resulted in material harm to certain groups of community. Further, the UK Supreme Court has held that it was arguable that based on the de facto management and a degree of control, a parent company owed a duty of care under English tort law to third-party claimants based in a jurisdiction that is different from that of the parent company. With regards to corporate failure to disclose climate risks, there was an Australian case in which a superannuation fund was sued by its members for failing to provide adequate disclosure of physical and transition climate-related risks that would impact on the fund's investments, thereby adversely affecting the financial interests of its members. The suit was settled in favor of the member, and the company acknowledged that climate-related risks pose material risks to the fund. Now, while such lawsuits do not seem to have yet been brought against companies in Hong Kong, directors must be very mindful of such litigation risks, which can result in reputational and financial damage to companies. In light of the increased litigation in other parts of the world and its likelihood in Asia, one cannot rule out the possibility of such lawsuits in Hong Kong. Let me now look at the measures that have been taken by the Hong Kong regulators in the past 2 years. The Stock Exchange of Hong Kong amended the ESG reporting requirements in 2020, and it states that the board has overall responsibility for an issuer's ESG strategy and reporting and disclosure requirements. Importantly, it set out compliant explained disclosure provisions in respect of certain ESG considerations related to climate change. One of these disclosure requirements pertain to 6 specific key performance indicators, such as the types of emissions and emissions data, direct and indirect greenhouse gas emissions, and total hazardous waste. I believe Ms. Christine Lau from the SCHK will speak more on the ESG reporting requirements. Now, moving on to the HKMA, in July this year, it issued the draft guidelines for the management of climate-related risk by authorized institutions. This document states that physical and transition risks will materialize in the near future with a high degree of certainty. And importantly, it states that authorized institutions have to make climate-related disclosures that are aligned with the TCFD recommendations as a minimum, and they have to do so by mid-2023. Consistent with the SEHK pronouncements, HKMA says that the board has primary responsibility on an authorized institution's climate resilience, and it spells out other responsibility that the board has to undertake, such as to incorporate climate risk considerations in the risk assessment framework and to build capacity to measure climate risk using various methodologies such as climate-focused scenario analysis and stress testing. The Securities and Futures Commission issued the consultation conclusions on the management and disclosure of climate risk by fund managers in August this year. Fund managers should incorporate climate risk in their investment and risk management processes. They should disclose Scope 1 and 2 emissions, assess long-term investment horizons. And consistent with the pronouncements by the SEHK and HKMA, the SFC states that the board should have overall oversight of board-related issues and set the tone from the top. So an important key takeaway from the measures and the pronouncements made by the SFC, HKMA, and SEHK is that the board of directors should take into account climate-related risks. Let me now look briefly at the key points in the legal opinion that is authored by Alex Stock, SC, and Jennifer Fun from Temple Chambers. The most important point, or I should say the conclusion that is arrived at by these 2 senior barristers, is that directors are legally required to take into account climate-related risks and considerations. Insofar as these risks will impact on the interests of companies, directors must keep themselves reasonably informed of such risks. Now, if directors fail to take into account climate-related risks, they may be in breach of their duties to the company if these breaches cause losses to the company. The barristers also said that directors should conduct thorough analysis of the risk in relation to climate change. Moving on to the key points in the white paper. Under Hong Kong law, directors are required to act in good faith in the company's best interests. But there are 2 issues that arise from this duty. What is the scope of the obligation to consider climate-related risks, and what if taking into account climate-related risks conflicts with short-term shareholder value? Now, with regards to the scope of the obligation to consider, the board has to show how it monitors and manages the risks arising from climate change. The process of monitoring and managing should include ensuring that adequate resources and expertise are devoted to identifying and assessing climate risks, allocating appropriate responsibilities to the relevant senior management and seeking expert advice, identifying and evaluating climate-related risks and the extent of their impacts on the company, and developing and implementing measures to address these material impacts on the company, such as investing in new technologies and adopting low-emission energy sources. With regards to the second issue, whether addressing climate-related risks will conflict with short-term shareholder value. This may occur since the measures to reduce or prevent climate-related risks may incur substantial expenses. Such measures could include long-term investments in or deployment of renewable energy and new technologies, upgrading existing equipment, or rethinking marketing and sales strategies in order to alter consumer behavior. These measures may result in substantial expenses that could lead to a reduction in short-term profitability and hence short-term shareholder value. But it's my view that if the purpose of taking these measures is to promote long-term shareholder value, long-term interests of the company, directors will not be in breach of their best interest duty. This is because under Hong Kong corporate law, corporate interest is equated with long-term shareholder value, long-term interests of the company. In addition to the best interest duty, directors are required under Hong Kong law to exercise reasonable care, skill, and diligence. How should we apply this duty to the climate risk context? There are 5 categories: risk management, due diligence, supervision, financial statements, and disclosures. Given that I've mentioned risk management and disclosures earlier, I'd like to look at due diligence, supervision, and financial statements. With regards to due diligence, directors should conduct risk assessment analysis of climate risk. Where a transaction involves investments in another company, due diligence would require directors to engage in both negative and positive screening to minimize all material climate-related risks. With regards to supervision, where non-executive directors have delegated responsibilities regarding monitoring the executive directors, or where the executive directors have delegated responsibilities to monitor and manage climate risk management, the former have to supervise the latter. And a higher level of supervision is warranted if the director possesses special expertise, such as those related to ESG or sustainability, or if the director holds certain senior positions, such as being the chair of the audit committee, or if there are certain matters that put the directors on inquiry. Now, with regards to financial statements, non-disclosure, inadequate or wrong disclosure of climate risk may result in a failure to comply with accounting standards requirement to give a true and fair view. So for example, directors may be in breach of the duty of care if material disclosures relating to stranded assets are omitted from the financial statements. They may also be in breach if the amount of bad debts is understated in the financial statements because they fail to evaluate the impact of climate change on the customer's ability to service and repay loans. Moving on to the last slide, that is enforcement. Should directors breach their duties to the company, several consequences may follow. The board of directors may take action against a delinquent director. The delinquent director may be dismissed by the shareholders at a general meeting. Should the board refuse to take action against a delinquent director, minority shareholders can bring derivative action lawsuits on behalf of the company against the delinquent director. But a major drawback of the derivative action is that any damages or compensation that the court will award will go to the company and not to the minority shareholders. Now, that said, even if minority institutional retail shareholders are reluctant to bring derivative lawsuits, one cannot rule out the possibility that environmental NGOs will buy shares in a company in order to bring such an action, provided that the criteria for granting leave for derivative action are satisfied. A more promising action seems to be unfair prejudice, namely the company's affairs are being conducted in a manner unfairly prejudicial to the members' financial or non-financial interests. A breach of directors' duties, such as a failure to consider climate risk, can amount to unfair prejudice. In addition to private enforcement, public enforcement is also available. The Securities and Futures Commission can apply to a court for an order if it finds that the company's business have been conducted in a manner resulting in any of its members not being given all the information with respect to the company's business that the member might reasonably expect. And the disclosure of climate-related risks is certainly one of them. As for the Hong Kong Stock Exchange, A breach of the ESG disclosure rules may attract sanctions from the Hong Kong Stock Exchange, and the Hong Kong Stock Exchange have several tools at its disposal, such as to impose a private reprimand, public censure, take remedial action. While there have been no such cases related to sanctions imposed on issuers for the violations of ESG reporting requirements, it does not mean that there will be none going forward. In short, in view of the well-established physical transition and liability risks that companies are subject to, in light of the major pronouncements and measures that have been taken by the Hong Kong regulators, directors of Hong Kong companies are and ought to be legally required to take into account climate-related risks, insofar as these risks have a material and foreseeable impact on the company's interests. Failure to take into account these risks may render the directors liable under Hong Kong law. Thanks very much.
Thank you so much, Professor Lim. That was a whirlwind tour of a lot of content. So I would direct you to the legal opinion and the white paper that Professor Lim has given you a wonderful guide to those documents. And now we'd like to call on Ms. Christine Lau to share the perspectives of the Hong Kong Stock Exchange on ESG and climate issues and their expectations of Hong Kong directors. We have you on mute, Christine.
Hello, everyone. Good afternoon. First of all, thank you, CCLI, for inviting me to this webinar today. I had the pleasure of listening to Professor Lim's presentation, and I agree very much with the findings on directors' duties in respect of climate change. Today, I will talk about HKEX ESG reporting framework and what we expect from board and directors. You will see that many of our expectations echo Professor Lim's findings. So in recent years, we have seen an increasing demand for ESG information from investors for their decision-making. In the past, investors have mainly relied on the company's track record to make investment decisions. But nowadays, investors are becoming increasingly aware that ESG factors, in particular climate-related risks, have an increasing impact on businesses. And therefore, climate-related information have become more and more important for investors' decision-making. These slides show how institutional investors have included climate and sustainability considerations in their stewardship expectations and voting decision-making. So ESG information is important, but how do we disclose it? So over the years, various sustainability reporting standards have developed. However, the voluntary and high-level nature of some of these frameworks was found to be conducive to greenwashing and may result in inconsistent and misleading disclosures. To address this issue, the Financial Stability Board established the TCFD, the Task Force on Climate-Related Financial Disclosures, to develop a framework to help companies and financial institutions consistently measure and communicate the climate-related exposures. The TCFD published its recommendations in June 2017. Since then, the TCFD framework has been widely adopted by governments, regulators, issuers, and investors around the world. Moving towards further standardization, in 2020, 5 major sustainability standard setters announced a joint statement of intent to present a shared vision of elements necessary for more comprehensive corporate reporting. In November 2021, the IFRS Foundation established a new International Sustainability Standards Board, the ISSB, to develop a global baseline of sustainability disclosure standards. 2 prototypes for climate and general disclosure requirements based on TCFD recommendations were published, and we are expecting a draft climate disclosure standard in mid-2022. So in Hong Kong, as mentioned by Dr. Lee, HKEX, together with other regulators such as the SFC and HAMA, has formed a cross-agency steering group to coordinate the management of climate and environmental risk to the financial sector. According to the strategic plan announced in December 2020, one of the key tasks would be maintaining TCFD-aligned disclosures by 2025. And in light of the new sustainability standard to be developed by the ISSB, the SFC, HAX, FRC, and HAICPA will also be working on a roadmap to evaluate and potentially adopt a new standard. So how has our ESG reporting framework evolved? Back in 2013, we introduced a voluntary ESG reporting guide. Then, since 2016, all listed issuers are mandatorily required to publish ESG reports on an annual basis. With effect from July 2020, the new ESG requirements come into effect with a focus on ESG governance and climate change. I will talk about these requirements in a moment. In 2020, as mentioned earlier, HAX became part of the cross-agency steering group. There is currently a time gap between the deadline for publication of financial information and ESG reports. So in our latest CG consultation in 2021, we are proposing to align the deadline for publication of ESG reports with annual reports to improve the timeliness of ESG information. For 2021 and onwards, we will continue to improve our ESG framework with a focus on climate change, in particular, moving towards TCFD-aligned disclosures. So this slide shows the new requirements that became effective since July 2020, many of which has incorporated TCFD elements. First, issuers are required to disclose the board's consideration of ESG matters. This includes disclosure on the board's oversight and governance of ESG issues and risks. The board also has to review progress against ESG-related goals. We also require issuers to disclose the application of the materiality and other reporting principles. This includes discussion on how the board determines ESG factors to be significant to the company and thus to be reported on. In response to the heated topic regarding climate, we require disclosure of significant climate-related issues which have impacted and may impact the issuer, and sets targets in respect of certain environmental KPIs, such as GHG emissions, both on a comply or explain basis. Lastly, social KPIs have been upgraded from recommended disclosures to comply or explain provisions. So, what do we expect from board and directors under the new ESG reporting framework? First, we expect directors to take leadership for and accountability in overseeing the company's ESG matters. While the board may delegate responsibility to the management team, the board should retain adequate oversight. To achieve this, there should be a clear governance structure for ESG matters, and updates should be reported to the board on a regular basis. The board should also ensure that responsible senior management possess relevant knowledge to carry out the duties. We also expect the directors to have a sufficient understanding of ESG issues. The board should appreciate how different ESG issues impact on the company and its business. They should understand that ESG risks are no longer merely reputational risks, but they may also impact on the company's financials. Regular training on climate-related issues may be required to ensure that the board is aware of latest developments. We expect the board to exercise oversight of the materiality assessment process. That is, the evaluation and prioritization of ESG issues. In particular, engagement with stakeholders is an important tool that companies may use to identify and achieve strategic responses to ESG issues. We encourage the board to be involved in this process, as this exercise enables the board to identify and understand climate-related risks, which may be overlooked by internal management. This understanding is also important for the board's review of the company's risk management process to ensure that adequate measures and controls are in place to identify and manage ESG risks that may arise. Next, setting goals and targets. The board's role, however, does not end here. In order to achieve targets, constant review and monitoring of mitigating and adaptive action taken is essential. Responsible departments should report to the management on the progress of achievement of targets periodically. This facilitates the management's assessment of the effectiveness of actions taken and make adjustments where necessary. The board should have oversight of the process and provide directions where necessary. The last 2 points here are interrelated. While the board should have sufficient knowledge on climate change in order to make meaningful decisions, employees' buy-in is also essential for a successful business model transformation. Promoting a culture from the top down is essential to ensure that climate and sustainability considerations are part of the business decision-making process. This facilitates the integration of climate and sustainability issues into the company's business strategy, which would lead to the eventual transformation into a lower carbon business model. Last but not least, I would wish to draw to your attention the various market education and guidance materials published by the HAX over the years. We have guides tailored for the board and directors, and also for report preparers. Last month, we published a new guidance on climate disclosures. It assists companies to prepare TCFD-aligned disclosures and suggests a work process and also provides practical assessment tools. We have also launched a one-stop ESG platform known as the ESG Academy on our HAX website. It houses all the guidance materials mentioned earlier and a lot more. So tackling climate change is one of the most pressing tasks of our time. It requires unparalleled levels of regional and global cooperation across every industry. And all of us have a critical part to play and to act fast. So I hope this presentation has provided you some insights on the board and directors' role in your company's ESG journey. Thank you.
Thank you so much, Christine. It's wonderful to hear your insights, the perspectives of the regulator, and then also the resources and tools that you are offering Hong Kong corporates to help navigate these really difficult issues. Now I'd like to turn to Ms. Alex Bidlake. If you could share your thoughts on the legal opinion and insights on what you're seeing as a trusted legal advisor to Hong Kong corporates and their boards.
Thank you so much, Ellie, and I would echo Christine's thanks for being here today. It's a pleasure to be with you all, with a terrific panel of very knowledgeable people and a great audience also. So I don't propose to recap on sort of the legal technicalities around sort of either the law or the listing and regulation, because I think Ernest and Christine have covered those excellently together with Emily already. What I would like to share with you all today, though, is just a little bit of practical experience from my time advising corporates, both on governance issues, but also on transactions. So I think it's fair to say that historically there's been very little focus on ESG in the region, rightly or wrongly. I think it's been seen as a cost with little benefit, unfortunately. But what I would say is that there's been a marked change in that over the last few years. And I think that change has been sort of driven by two key factors. One is regulation. You know, people have to do something because they are required to do so. And that's something that I think started very much more in Europe, with a huge amount of green regulation being brought in. We're a little bit behind perhaps in Hong Kong, but as you've already heard from my fellow panelists, there's a huge amount going on here from the various different regulators really driving for change. I think the second key driver of change is around investor scrutiny. I know that this has been mentioned already to a certain extent, but what we are seeing sort of boards telling us is that they are coming under significant pressure from investors, particularly the big institutional investors that they have as shareholders, to really articulate their approach to climate change and sustainable development. And in particular, they're now being held accountable for and being required to provide clear ideas around transition plans for a net zero future. And that's something that I think has been a real shift in attitude from investors, which is driving change in the corporates. And I think, the stick that drives this as well is the real risk of litigation. So the rise of activist investors and the fact that litigation, I think, started off just focusing on accountability and changing practices. But I think there has been a bit of a shift to also seeking monetary compensation. And where money is on the line, that also is quite good at focusing people's attention on the issues at hand. So what has it seen in practice? I'd say there's probably been three key things that we've been advising clients around. So firstly is in relation to the reporting. So as Christine mentioned, the Hong Kong listing rules has for some time had mandatory reporting on ESG matters. And so, all the listed companies here have been reporting. But it feels to me that it was very much more of a management-led process historically. And it's only now that it's really starting to get the attention of the boards. So this year alone, we've been in to see, a number of our listed company clients to sit and advise the boards on their duties and responsibilities in this area. And I get the feeling that they really are focused on this in a way that they perhaps weren't so much before. So the companies were still doing good things. They were still trying to drive ESG related initiatives, but it wasn't necessarily getting such high scrutiny from the boards. And that has been a marked shift. And that's in the listed companies particularly. It's obviously slightly less relevant to private companies because whilst Ernest is exactly right that there are director duties and therefore actions can be brought against directors, that generally requires it to be brought either by the board or by shareholders in derivative actions. And if the directors are also the owners of the business, there is less accountability demanded of them in many cases. But what we are seeing is that many private companies have in mind a route to listing. And so as part of that process, they bring in institutional investors. And so the focus of institutional investors then I think really forces some of these private companies in the pre-IPO world to focus more on ESG risks. And also private and public companies are increasingly subject to negative press if they're doing things that are either not actually in line with climate or other environmental good practices, or are not perceived to be. So I think it's very much become very much more important, perhaps from a perception perspective, really to ensure that people are doing the right thing and not just sort of talking the talk, they are actually walking the walk. And those all sound sort of maybe negative drivers. I think the final point I would make is that there have also been some very positive drivers to this, because corporates see many opportunities in the focus on the environment. So, green finance, sustainable bonds and the like, there's been a huge uptick across Asia, but also within Hong Kong for green finance. And there's obviously risks associated with that around greenwashing and the likes. But what we're seeing from our issuer clients who are raising this finance is it's something that they are truly focused on. And therefore, it's something that they want to do, that they're doing it properly, but they can also raise money out of that. So that's obviously a terrific opportunity. I think the second and final point I'd say in terms of opportunities is around investment in renewable energy. So we've seen a whole swathe of investments in offshore wind, onshore wind, hydro, solar. These are things that I think have been happening for a while, but there is just a sort of a rolling ball of momentum that we're seeing a huge amount more. So the focus originally was around Taiwan. I always get the impression that Taiwan is surrounded by offshore wind farms because there are many, many people investing there. But we've also seen the same in Japan, in South Korea. We're starting to see many more opportunities in mainland China. Looking east, we've helped people in Vietnam, in India. There's a whole range of different target zones for people, particularly for some of the big funds, including the likes of BlackRock that I think Christine mentioned earlier. And so that is seen as a big opportunity for people, and the region is throwing up a lot of opportunities to investors from around the world. So we are seeing, I wrap up by saying we are seeing a huge amount more focus on this. I expect that to only continue as more regulation comes into play, more institutional investors are demanding in this area. And I think it's a very exciting opportunity and a very important one on so many levels. With that, I will pause and pass back to Ellie.
Thank you, Alex. I think Ellie's having a few connection problems at the moment. We've lost her temporarily. So in the interim, I'll jump in. My name's Sarah Barker. I'm the Australian convener of the Commonwealth Climate and Law Initiative and a partner at Minter Ellison, which is a largely Australian-based firm, but the largest commercial firm in the Asia-Pacific region. Ellie had asked me to share some reflections on the stock opinion in the context of our experience here in Australia with the Hutley opinion. And certainly it was an absolute pleasure to read the stock opinion, and also Professor Lim, your white paper that followed. I found them both very, very clear and very, very compelling. But I wanted to share some reflections with you about how potentially significant these opinions may be based on our experience in Australia with the Hutley opinion. So Australia, you might not think, is known for having a progressive climate change policy. You'd be right. I think we're the only developed country that has the distinction of having had a carbon tax that was then repealed back in 2014. And the fact that our carbon tax was repealed really perpetuated this sense amongst the director community and also the corporate law community that climate change was not a financial risk issue, nor was it a legal risk issue, because there was no hard law regulation to compel any kind of compliance response by a company. But of course, those of us who spend time thinking about climate as well as corporate law understood that if it's a financial risk, then directors are duty bound to consider it and to disclose material risks to their company. So we commissioned or instructed Noel Hutley SC, who was at that time the president of the Australasian Bar Association, a very senior commercial lawyer without an environmental bone in his body. I'm sure he wouldn't mind me saying, very well regarded in corporate law circles, and briefed him with a similar brief of evidence as Professor Lim has set out in his white paper and Mr. Stock in the Stock opinion around how climate change has evolved to be a material financial risk, and asked him to opine on whether or not that enlivened directors' duties in relation to climate change. And he responded in the affirmative. And you might think, okay, an opinion from a barrister, dime a dozen, they happen every day. But it was very interesting what happened. It was picked up by the financial press. It was picked up by our prudential regulator, APRA. It was picked up by our securities regulator, ASIC, by our Reserve Bank, by our Accounting Standards Board, by our Auditing and Assurance Standards Board, as the legal foundation that they had been missing in order to base their own shift in their enforcement position and their public guidance to companies in relation to directors' duties in relation to climate change. Now in Hong Kong, there 5 years later, you are in a much better position where you do have Hong Kong X, you do have HKMA, you do have the SFC taking their own leadership in this field. But I certainly have great confidence that the Stock opinion and Professor Lim, your white paper, will have similar influence amongst the directorship community and certainly amongst the corporate law community as that theoretical foundation that we really, really need in order to disabuse directors of any misunderstanding that climate change is a positive obligation that they need to take into account.
Thank you so much, Sarah.